Before we jump into today's video, which is going to be on the most recent motion that was filed in the Karen Read case, and don't worry, I'm not going to read for you the entire motion. By now, I'm assuming that other channels have already read the entire motion for you, or maybe you read the entire motion, so you kind of have an idea about what's going on. Rather, we're going to actually jump into the legal analysis and do some research and show you what my research has shown about this specific issue. So we're going to get into that very soon. But before we do, I want to just take a few moments to recap what happened last night when I had a live stream with Kate and Kevin from Yellow Cottage Tales and Kate from Masso Mafia. Like most of you know, originally I put out the offer for any attorney who believes that Karen Read should have been found guilty to come onto my channel and discuss it. I didn't get any attorney to take me up on the offer, but I did get Kevin and Kate to take me up on the offer. So I brought them on and we had a discussion. Now, part of what I was trying to show everybody is that you don't have to get all red in the face and scream and cut people off and call people names and shake your hands and fists and tell them that they're ridiculous. You don't have to do that. What you could do with these people that have a different position than you is just let them talk, let them argue, and then calmly and rationally take apart their arguments and show why their arguments don't really hold any water, don't hold any sort of merit. And that's exactly what I was trying to do, showing that, especially when we talk about the ARCA experts, it seemed to me that we were going in circles because they kept reiterating that, well, they didn't have all the evidence. And then we said, okay, well, what evidence didn't they have? They didn't have this evidence. That evidence is not important. What about this evidence? They didn't have that. Trooper Paul's report. Who cares about Trooper Paul's report? So we went through each of these pieces of evidence that they claimed that the ARCA experts didn't have, and therefore their opinions are completely not credible. And I calmly explained to them and rationally explained to them why it doesn't make a difference. And then they tried to argue about, well, they didn't say that the interaction couldn't have happened. Well, actually, they did say that. They said that the interaction, as the Commonwealth explains, could not have happened. There's no way that car hit any part of John O'Keefe going 24 miles per hour. If it did, then there would have been significant bruising, which means that it's against the science. It doesn't matter whether his arm was outstretched or up. If that car hit that arm on a side swipe, there would have been significant bruising. The only option possible that Dr. Rensler said was that if there was a tiny tap, that's possible. It's possible, just like the million other possibilities. Maybe he slipped on ice. Maybe when he was walking, an animal scared him. There could have been a numerous amount of possibilities, and that was just one of them. Oh, maybe the car bumped him. And obviously that was not the Commonwealth's theory. The Commonwealth's theory was that Karen Read backed her car into him going 24 miles per hour. That was clearly debunked by the ARCA experts. And the argument that there was not enough evidence and they only had a very limited scope, we already debunked that argument so many times. And that's kind of what I was showing on that with that live stream, that just calmly, rationally explain this to them. And then, either they'll just dig their heels in and refuse to believe it, or they'll say, well, all the other evidence points to her guilt, so therefore let's ignore the ARCA experts. So I don't like to ignore ARCA experts, especially when they go uncontradicted. And I said, yeah, there may be some evidence that points to her guilt, but at the end of the day, if the science does not, or physics and science does not support that this interaction ever happened, definitely the way the Commonwealth is saying that it happened, well, then that automatically creates reasonable doubt. So I think that was very clear. We went through some of the other evidence as well, and maybe I can do a much more of a full recap of the discussion and the different points that we made. But that was just kind of the general feeling that I wanted to show everybody, that you can just calmly and rationally take apart these arguments and they fall flat. So anyway, let's move forward with today's motion. So I'm just going to read for you just a little part of the motion, because this is really what it comes down to. We know that there's this argument, the allegation here is that there is some missing footage of the Sallyport video, right? The Sallyport video, there's missing footage, and therefore they want a complete copy of, or forensic download of that security video, that video in the Sallyport, to be able to see exactly everything that happened in that Sallyport from the beginning to the end. And that is what they were trying to accomplish. And they're arguing that they were not, again, the Karen Read side is arguing that they were not able to get that forensic download. They hired an expert. The expert came and spent all this money. And really, let's remember that this motion is a motion just to recover the costs, of this expert that Karen Read had to pay out of her own pocket, something like $12,200, in order for them to travel all the way to Massachusetts and stay overnight. And it cost a lot of money for an expert to just take off a full day of his time. And it turns out that nothing was available for him to actually even do. So that's essentially what the argument is in this motion. But what we're getting a little bit of a preview is that there is going to be a motion to dismiss this entire case coming down. That's going to come sooner or later. And it's going to be based on this Brady violation, essentially. And remember, Brady basically says that a prosecutor has a duty to turn over all exculpatory evidence to the defense, and they have a duty to preserve that exculpatory evidence to the defense. Okay, so really, I'm going to show you what this issue hinges on, because I think maybe people didn't realize this, but really it hinges on one specific issue. Okay, so let's just pull up a little part of the motion. We'll read a little bit of this together, not a lot, because you probably read of it all, but I'm going to tell you what I think is the important part that we have to concentrate on. Okay, so we're talking about Mr. Erickson. Mr. Erickson is the person who was hired. This is the expert. So I'm just jumping into the middle because I'm assuming you're all pretty familiar with what happened in this case, in this specific motion. Next, Mr. Erickson began the process of generating any activity logs for the date of interest. So this is some way that you're able to see what happened to that video, whether anybody did anything, whether anybody altered it, whether anybody downloaded it, whether anybody deleted it. So there is some way that you can get this information. So he was trying to generate these activity logs for the date of the interest, meaning around this time, January 29th. What happens? This request ran for an abnormal amount of time without showing results. So why is it not showing results? How can there be no activity during that time? When asked whether the system had ever behaved this way and whether it could be expected to complete the request, the person on site who was most familiar with the system shrugged and said he didn't know. After investing approximately 10 minutes into this and similar actions with no results, Mr. Erickson determined that the relevant activity logs were also gone. So the activity logs were gone. Now, also, he was not able to get the video, right? He wanted to get an original forensic download of this video, and that was what happened first. He wasn't able to get it. So then he decided, okay, well, if I can't get that, at least let me get a download of an activity log to see, hey, why can't I get this? What happened to this video? And he wasn't able to get that either. Okay, so now let's move on. Mr. Erickson asked individuals whether they had done a forensic extraction of the drives to get the original data. So the question here is, how did the Canton Police Department download this video? And his question was, did they do a forensic extraction of the drives to get the original data? Apparently, there's different ways to get the data, to download the data. One of them is this called a forensic extraction. And if you do it that way, that's the way that the industry has been accepted. That's the industry standard. To which they answered no. So they said that no, we did not do it that way. So then he asked how they preserved video when they needed to. If you don't do a forensic extraction, how exactly do you do it? I mean, there's a lot of different ways that we know how to copy videos or copy, documents or exhibits. We have all different. People take pictures with their phone. That's how they make a copy. People do all types of different ways, but obviously there's a much better way. There's an industry standard, definitely when it comes to forensic extraction, how you're supposed to download this material. So we asked them, how do you, when you need to preserve a video, what do you do? When they need to. And they responded that they simply manually save the video from the DVR. Finally, he asked if they had a written protocol in January 2022 or now for saving video. I mean, there should be some sort of protocol. This is important stuff, right? You're trying to throw people away in prison. There's got to be a protocol. There should be some policies about how you preserve evidence or videos, right? That has to do with evidence. They responded that they did not. So they don't have a policy. They don't have a protocol. They don't have a procedure of how they're supposed to download and save these videos. Okay. And then he says the individuals refused to provide Mr. Erickson with a copy of the original video files that they pulled from the DVR system, stating that it had already been provided to the defense counsel. Okay. And when asked how they produced the footage to the court and or the defense, they looked confused. Mr. Erickson clarified by asking whether it was provided on USB disk, drive disk, or share link. They could not tell him for sure, but eventually said it was probably a share link. Okay. So that's really all I want to pull out from this motion. Okay. So this is, I think, the most relevant facts that we need to know. He came there, he tried to do the download, he wasn't able to do the download, and then he tried to do a download for the activity logs. He wasn't able to do that, so now his time was a waste. It was a waste for him to go and travel this far. So in this motion, they're asking to have his costs reimbursed. Okay, now so happens to be that generally speaking, I didn't see any sort of case law that allows for this type of remedy. Okay, there's a bunch of different remedies. You can always ask for different remedies when there's playing around with evidence, but I have not yet seen in Massachusetts state law, and I didn't see any quotations in this brief. Like I always tell you, if you want to ask the judge for something, you've got to show where in the law it allows the judge to give you that. It's something that we always stress on this channel. And there was nothing really clear in this brief showing that you could get your expert's cost reimbursed. I definitely didn't see anything. like that. So there are other remedies available. Okay, and that's what the remedies eventually they're going to ask. Now they're asking for this, and they're going to say this is bad faith, and they'll make some general arguments like that. But if it comes down to actually citing to a specific case which says that you could get reimbursed for expert costs, I did not see that quoted in their brief, and therefore that may be the end of this issue, unfortunately. But there are other remedies available. Okay, and this is where it comes to the Brady issue. This is really what the more important issue is. Okay, I'm sure Karen Reed would not mind spending this $12,000 if it means that she's completely acquitted from this case, if the case does not go forward. And therefore, she doesn't have to pay this in defense team with Robert Alessi, David Iannetti, and Alan Jackson, Elizabeth Little, all their hourly billable hours to try this case again. I'm sure she'd much prefer to swallow this $12,000 bill and then be completely acquitted, because that's going to be the next motion. Okay, and they already said this in a footnote. I don't have to read the footnote. You probably all saw the footnote. But in that footnote, it said that they are going to follow this up with a motion to dismiss the case. So what does it come down to? Okay, what does this come down to? So look, really the question that we have to ask is the following. The question is, who says that the Canton Police Department or any prosecutor in any sort of case has to always provide originals? Who says that they have to do that? Maybe providing a copy of all the evidence and saying, look, this is the evidence. This is a copy of all the evidence, and that's good enough. Who says that originals are even important? Okay, so this is where and this is where it comes down to, because what the Canton Police Department and the prosecution is going to argue in this case is that, look, we turned everything over. We did all the downloads. We turned everything over. There's nothing that we're hiding. There's nothing to see here. If you want to cross-examine on that, you can do that. But we, as prosecutors, as the Commonwealth, did not do anything wrong. Okay, just because we're not providing with you the originals, who says that there's a requirement to provide originals to you? Right? That's the ultimate question. So what this comes down to, and this is an issue obviously that the defense understands, and they talk about a case, and there's a specific case, and this is the case that's really going to hold the day with this. And that's why we're going to discuss this case, because that's what we do on this channel. So the case is, let me just pull it up here. The case is Commonwealth versus, get this, Harwood. Commonwealth versus Harwood is the seminal case that deals with this specific, very, very similar issue. Okay, so let's go through this case a little bit, because this is most likely what they're going to be arguing using this case. Of course, they're going to quote other cases, but this is a very important case in Massachusetts, and this is what they're going to be arguing about. They talk about in this motion, but eventually the more important motion, which is coming down the pipe soon, about this motion to completely dismiss the case because of a Brady violation, that's going to be the question. So again, let's just frame this properly. If the prosecution does not turn over exculpatory evidence, that's a Brady violation. And there's different remedies that are available when there's a Brady violation. One of them is complete dismissal of the case. One of them is excluding that specific evidence or any sort of negative inferences from that evidence. But here, right, and there's a bunch of different remedies. Okay, there's different remedies, but the question is, whether there is a Brady violation at all. Are they suppressing exculpatory evidence? And here the question is going to be, well, is it considered suppressing exculpatory evidence if we don't provide the original? Is it good enough if we provide the copies and we'll sign under affidavit that we provided everything to you? We're not hiding anything. We provided everything that we have. So who says that you can start arguing, well, we need originals? Who says? So this is the case, and let's go through the case. So what happened in this case is actually not like a murder case, okay? But let's just go through it. The defendant, Frank Harwood, was indicted by a special grand jury on charges of insurance fraud and larceny over $250 based on evidence that he may have filed a fraudulent workers' compensation claim with ITT Hartford Insurance Company. Okay, so this is a claim that this guy filed. He was committed fraud, insurance fraud. He tried to fraudulently get workers' comp money, and he really wasn't injured. He didn't deserve for workers' comp money. Okay, so the claim involved an injury that reportedly occurred on June 29th, 1989, while he was employed by the Scola Construction Company. The Commonwealth asserts, again, workers' comp is when you get injured on the job, right? When you get injured on the job, then you get certain benefits. So he was claimed that he was employed by Scola Construction Company, and that's when he allegedly got injured, and therefore he claimed that he was entitled to workers' comp. And that's what he made this claim for with Hartford Insurance, and turns out, according to the, again, this is a criminal case, that he committed fraud. insurance fraud. The Commonwealth asserts that it was prepared to show that the defendant had defrauded ITT Hartford by submitting a false claim of concurrent employment at Strand's ski shop that led to ITT Hartford paying the defendant higher workers' compensation benefits than if he had not been working at Strand's at the time. So, what were they trying to prove here? Well, he was trying to prove that he was also working at Strand's ski shop. So not only was he working at Scola Construction Company, but he was also employed, is what his claim was, that he's also employed at Strand's ski shop. And therefore, what happened? ITT Hartford, this insurance, ended up paying him more than really he deserved. The defendant's claim of concurrent employment was allegedly supported by a document in the missing file at issue here. So here there's a missing file and there's a document, a February 5th, 1990 letter on Strand's letterhead purportedly signed by Leif Mickelson. So how do you prove that you're employed at for a certain company? You get the person who's in charge of you, your supervisor, to sign a letter. So here you've got this letter, February 5th, dated February 5th, 1990, which was on Strand's letterhead, that's the company he's claiming that he works for. And on that letter, which was signed by a Leif Mickelson, who is a co-owner of Strand, so this is an owner of the company saying, yes, this guy works for us, attesting to the defendant's concurrent employment. The Commonwealth asserts that the evidence indicates the signature on the lost February 5th letter was not Mickelson's. So what the Commonwealth was claiming in this case is that this guy forged that signature. He forged the signature by Leif Mickelson saying that he works for this company. That's fraud if he actually did that. So that this February 5th, 1990 letter was important. But it was lost. It was lost. That letter was lost. The defendant claims that handwriting analysis on the lost original would have nullified Mickelson's testimony against the defendant by establishing that when he denied the signature on the letter was his, he lied as an immunized witness before the grand jury. So this guy Mickelson, who testified that that's not my signature at all. Well, if we would have had the original letter, we could have had an expert testify that it is his signature. And therefore, that would have definitely helped the defense in this case, right? The defendant is claiming that the charge here is against the defendant that he forged this signature. Well, we can have an expert who's going to testify that this is actually an accurate signature, an authentic signature of Leif Mickelson. And therefore, obviously, the defendant did not commit any fraud. So this would have been very important for the defendant in this case. So now let's go back. They go through a lot more background here, but that's essentially what the case is. And let's see what they end up saying here. So the remedy for missing evidence. The general rule is that the Commonwealth has a duty to preserve exculpatory evidence for the defendant to inspect, examine, or perform tests on. Okay, so any exculpatory evidence, the Commonwealth has a duty to preserve it. We have repeatedly stressed the need for prosecutors to do their utmost to preserve and present exculpatory evidence which is available to the prosecution. So they have to do their utmost to preserve and present exculpatory evidence. Okay, but we're not up to the part of the letter that it's a copy. You know, they did produce a copy of this letter. Okay, that's the part that I did kind of left out here. They did produce an alleged copy of this February 5th letter. So here exactly was the issue. Do you need the original letter? Can the defendant argue that since they lost, they did not preserve the original letter, so therefore this is a Brady violation? Or, and therefore the case gets dismissed, or no, the fact that they produced a copy of the letter, that's good enough. And since they produced a copy of the letter, they can't argue, well, how do we know that that this copy is accurate? Maybe it's not accurate. They can't argue that. So that was part of the question in this case. Can the defendant argue that because we did not have the original letter, that means that this is a Brady violation? So that's almost exactly the similar situation what happened in our case. Let's continue in the Karen Reed case. So again, we have repeatedly stressed the need for prosecutors to do their utmost to preserve and present exculpatory evidence which is available to the prosecution. When a defendant claims he is prejudiced by missing evidence, a judge must weigh the materiality of the evidence. So the first thing you have to do is weigh how important is this evidence. You want to claim that, the original, some original evidence is missing. Well, how important is that to your defense really? So that's what the judge has to do. He has to weigh, number one, or she has to weigh the materiality of the evidence and the potential prejudice to the defendant. And that's not it. But also meaning, what type of prejudice is this to the defendant, the fact that you don't have the original? What type of prejudice does that do to the defendant? Is a copy the same thing? If a copy is the same thing, then come on, it doesn't really prejudice the defendant. So this is not an idea that, oh, we can never trust the Commonwealth. And you should, the Commonwealth should always have to produce originals. No, that's not the way it works. Okay, it's not the way it works. But what you do have to show is that you need, this is material, this specific evidence, and by not having that original, it prejudices the defendant, as well as the culpability of the Commonwealth and its agents. Meaning, how badly did the Commonwealth mess up here? Was it really their fault? Or is this just some sort of crazy fluke that they don't have the original? So that also has to be weighed. All right, let's continue. Again, negligence. So what happens when it comes to negligence? Let's say the Commonwealth is just negligent. You know, they didn't do this on purpose. This wasn't intentional, but it was just negligence. Is that enough to assert a Brady violation? So this is what this case says. Yes, negligence and inadvertence are considered culpable for purposes of this weighing. As we shall describe, the judge applied the correct test, and we will not disturb his findings in such a circumstance in the absence of clear error. And here again, we have said another part is that even just evidence tending to impeach the credibility of a key prosecution witness is clearly exculpatory. So even if you just have evidence which you can use to impeach one of the main witnesses for the Commonwealth, that's also considered exculpatory evidence, which needed to be turned over. And if it wasn't, and the Commonwealth is culpable, which means even negligence or inadvertence, meaning we inadvertently deleted it. It wasn't intentional. We just inadvertently did it. You're still culpable. You're still culpable. That's exactly what this case stands for. So in this case, I don't know if I highlighted this part here. The defendant's expert in a report admitted in evidence stated that the authorship of the signature on February 5th letter could not be determined based on the photocopy examined. And the judge concluded that the defendant requires the original of the letter in order to obtain a handwriting analysis. So this is why it's so important in this case. And this is what you all have to understand. It's not just to say, well, we don't have the original and therefore Brady violation, red flags, throw the case out. No, it doesn't. It's not just that. Okay, so we keep saying it's not just the fact that you can't get the original. If the Commonwealth is able to produce a copy which is just as good as the original, this argument falls on its face. The reason why in this specific case in Harwood that this was an issue is because the expert testified that the authorship of that signature, meaning that signature of the February 5th letter, could not be determined based on a photocopy. So whatever copy they had of that letter, the signature wasn't clear enough for the experts to be able to analyze it and tell you whether it's an authentic signature or not. So there you see, in this case, you needed the actual original evidence. That's what you needed in this case in Harwood. And because they were not able to produce the original, even though maybe it was a mistake, it was inadvertent, maybe it was just negligence, still the judge found in this case that there was a Brady violation. Okay, so there's a violation in this case, in the Harwood case. And therefore, that's the argument over here. So now what's the argument? How do we connect that to the Karen Reed case? And then what are they arguing? Well, they're arguing the following, that when it comes to the Sally Port video, is it enough just to have a copy? Is it enough just to have the copy? Why can't we trust the Commonwealth about the copy of this video? Well, that's exactly what they lay out in their motion. And they say, well, look, we know already that we can't trust the Commonwealth when it comes to copying. Because look what they did. They inverted the video. Some video was missing. They showed up with video in the middle of a trial. I mean, give me a break. We can't trust the copying. It'd be one thing if they copied it and it's pristine. It looks stunning. You can see everything clearly. There's no inverted videos. And, they produced it months before the trial. Okay. Then Alan Jackson would say, you know what? Okay, maybe there's not a red flag here to wave and say there's a Brady violation. But part of their motion is that here we have a Sally Port video where we have already seen that there's some gamesmanship when it comes to this video. It's inverted. First, we got a really garbage, crappy video copy. And then all of a sudden, a few weeks into trial, we got the real copy of the video. I mean, obviously, something is going on there. And therefore, the same way in that handwriting analysis, the expert said, I can't trust this copy. I can't really make much out of it. So too in this case, we cannot trust the copy. So again, it comes down to this issue of whether you can actually trust the copy. It's not just because you can't produce the original. So if anyone's go out there saying, oh, if they can't produce the original, that automatically means a Brady violation. That means that they didn't watch this channel. They don't see the cases. You didn't do the case. You didn't do the research. Okay, but this is what it comes down to. It comes down to the fact that since they're arguing that the Commonwealth did not preserve a copy of this Sallyport video well enough, and you can tell by the way that they're turning it over last in the middle of a trial, and things are changing and inverted. Obviously, there's a problem with their process and their copying, and therefore we need an original. And if they cannot produce an original, well, then guess what? That is a Brady violation, and therefore this case should be dismissed outright. And before that happens, most likely, I mean, even if we get to this far, there's going to be another evidentiary hearing. Okay, in case we don't have enough of evidentiary hearings, most likely, if this goes anywhere. And again, we have to see what the Commonwealth is going to respond, what Hank Brennan is going to respond to this. But if we get anywhere, it's going to most likely end up with a evidentiary hearing to see what exactly was going on with that video, and to have everybody testify about it. And crazier things have happened. I mean, we've seen, if you were following the Alec Baldwin case, this happened in the middle of a trial where they discovered that there was something that was not turned over to the defense, and it was exculpatory, and the judge threw the case out. So, whether the judge is going to throw this case out, there's probably some doubts out there. I can't say that I am completely confident that this is going to win the day for Judge Cannone to throw this case out. But this is a compelling argument. This is not just a throwaway argument. This is definitely, by the way the defense is filing this motion, by the allegations that they're making, and from what we all saw with our own eyes during the trial, how this case was, the video was inverted, and there were some problems, and that there was a late disclosure in the middle of the trial, Rule 14 violation, no question. So still, that's why this motion can actually go somewhere. So we haven't seen the full motion yet. I'm just preparing you kind of, because this motion is just about the motion to recoup the costs, which I said that may not get anywhere because I haven't seen any clear authority in Massachusetts that allows for that. And they certainly didn't quote any cases that stand for that also specifically. But the next part of this motion, which is the motion that's coming down the pipes soon to dismiss the case outright, that is going to be interesting. And they may, buff it up with some more case law, and we'll have to analyze it when they actually get to filing this motion. So this was kind of like a little bit of a preview of what we're probably going to see. And of course, as the motion gets filed, we will, when they file that motion to dismiss the case, we're going to go through that, see if there's any other cases that they cite, and we'll research, we'll review it, and see what other context we can provide for that. So that is going to be it for now. Thank you all for tuning in. If you haven't yet, please subscribe, like, and we will see you next time.